It is fit and proper that it be the one to determine this issue, notwithstanding that the parties herein all extensively submitted on this limb of the amended petition. By filing two distinct petitions in two different stations, the petitioner has created an uncomfortable situation where, in essence, there is a possibility of the petitioner enjoying two bites at the cherry, as it were. Perhaps more importantly, the petitioner's choice of crafting two distinct petitions with minimal overlap, such that consolidation would not be automatic, has had the consequence of denying a single court a bird's-eye view of the entirety of the process, from the inception at the County Assembly to the Senate resolution, and thus forcing two High Court stations to tread carefully so as not to stray into the other's case. To be clear, this was not forum shopping, but rather it was clever lawyering, where the petitioner's counsel identified a loophole that they could use to the benefit of their client. By drafting and filing a petition before this court in which all the allegations were limited to the Senate stage, and by only suing the Senate Speaker, perhaps fully aware that the County Assembly and its officers would be forced to join the proceedings through applications for joinder, the petitioner has created a situation where she now has two opportunities for success rather than just one. As discussed earlier under the limb of the court order and whether it was violated, this court is limited by the amended petition to only the Senate stage aspect of that limb, with the petitioner still having another opportunity in the County Assembly stage challenge of the same limb, which is pending before the High Court in Meru. As we continue to fine-tune the practice and process of litigation in the High Court on the subject matter of gubernatorial impeachments, this is certainly a loophole that must be firmly closed by the courts in future impeachments, if a similar situation were to arise. This would not only make adjudication of the dispute more wholesome and comprehensive, but it would also ensure that all the petitioner's grievances are laid before a single court, which would be able to take a holistic view of the matter rather than being constrained to a more limited view. Therefore, while the constitutional validity of Section 33, subsection 8 of the County Government Act poses legitimate legal questions, both in favor of and in opposition of its constitutionality, this court declines to determine the same within this judgment, as the same is pending before the Meru High Court in a related matter which was filed earlier in time. Whether the threshold for public participation was met in the impeachment process. The issue of whether the threshold for public participation was met in the impeachment process is central to the petitioner's argument that the impeachment proceedings were unlawful. Public participation is a constitutional requirement under Article 10, Clause 2, Paragraph A, and Article 196(1)B of the Constitution of Kenya 2010, which mandate inclusive and meaningful citizen engagement in government decision-making, including legislative processes such as impeachment. However, public participation in impeachment proceedings primarily occurs at the County Assembly level rather than at the Senate level, since the County Assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for the final determination. The petitioner contends that the public participation process was inadequate or manipulated, thereby rendering the entire impeachment invalid. However, the respondent and the interested parties who support the respondent maintain that public participation was conducted in compliance with legal requirements, and any challenge to its inadequacy should be directed at the County Assembly rather than the Senate. Once more, this court is treading delicately so as not to stray into the province of a petition that is pending before the High Court in another station, and thus refrains from an in-depth analysis and determination of this issue, despite the parties having canvassed it at great length. This situation, as stated earlier, is a direct consequence of the drafting and filing choices made by the petitioner, which resulted in two live but distinct petitions pending before the High Court sitting at Meru and sitting at Milimani, Nairobi. Given that the petitioner has not sought adverse orders against the County Assembly, The court finds it procedurally improper to determine this issue in the present petition, as it is already being addressed in a separate case before the Meru High Court, in which the matter of public participation is at the core of the petitioner's grievance against the County Assembly. For the purposes of this amended petition, it is the finding of this court that the amended petition has not shown a correlation between its allegations on public participation and justiciable grounds against the respondent and the Senate within the four corners of the amended petition that is before this court. The next issue, whether the threshold for impeachment of the petitioner was met. The question of whether the threshold for impeachment was met revolves around two key legal considerations: whether the charges against the petitioner constituted valid grounds for removal under the Constitution, and whether the High Court should conduct a merit review or a process review of the impeachment decision. The petitioner and the interested parties who are in support of the amended petition contend that the allegations against her did not amount to gross misconduct, abuse of office, or gross violation of the Constitution, as required under Article 181, Clause 1 of the Constitution. On the other hand, the respondent and the interested parties who oppose the amended petition argue that the charges presented before the Senate were serious and substantiated, thus meeting the legal standard for impeachment. The Constitution of Kenya 2010 under Article 181 Clause 1 states that a governor may be removed for office for 1. Gross violation of the Constitution or any other law. 2. There being serious reasons to believe the governor has committed a crime under national or international law. 3. Abuse of office or gross misconduct. Or 4. Physical or mental incapacity to perform the functions of the office. These requirements are mirrored in Section 33 of the County Governments Act, which outlines the procedure for impeachment, requiring an initial resolution by the County Assembly followed by a Senate hearing and vote. The Senate is tasked with evaluating the sufficiency of the charges and determining whether the evidence meets the constitutional threshold. Courts have consistently ruled that impeachment is not a purely political process, but one that requires objective and verifiable evidence of wrongdoing. Several landmark cases have clarified the legal threshold for impeachment, reinforcing the principle that impeachment must be based on substantive proof of serious wrongdoing. In Martin Nyaga Wamboro versus Speaker of the Senate and others 2014, the Court of Appeal held that impeachment must be based on evidence of gross violations of the law, not on minor procedural errors or political differences. The decision emphasized that governance mistakes or administrative inefficiencies do not automatically amount to gross misconduct warranting removal from office. Similarly, in Governor Ferdinand Waititu versus County Assembly of Kiambu and the Senate 2020, the High Court ruled that impeachment should not be misused as a tool for political maneuvering, but must be based on serious and substantiated allegations. In another seminal case, Mike Sonko versus County Assembly of Nairobi and Senate 2021, the Supreme Court clarified that the threshold for impeachment requires proof of gross misconduct and significant breaches of the law. In the current case, the Senate reviewed the allegations against the petition and found that they met the threshold for gross misconduct under Article 181(1), meaning that the charges were serious enough to warrant removal. Applying this principle, if the Senate found the allegations against the petitioner to be serious, backed by evidence, and meeting the constitutional standard, the impeachment should stand. A crucial legal question in this case is whether the High Court should conduct a merit review, reassessing the correctness of the charges and the evidence, or a process review, assessing whether due process was followed. Courts have consistently ruled that judicial review of impeachment should focus on ensuring procedural compliance rather than assessing the merits of the charges. In the Supreme Court case of Peter Munya, the Apex Court emphasized that judicial intervention in constitutional processes should be limited and should focus on procedural fairness rather than the correctness of legislative decisions. Similarly, In Wambora versus Speak of the Senate and others, Supra, the Court of Appeal held that the High Court's role in impeachment cases is to ensure that the process followed the legal and constitutional requirements rather than substituting its own judgment on the allegations. The Supreme Court further reinforced this position in Sonko 2021, where it ruled that the Senate and County Assembly have the constitutional authority to determine impeachment matters, and courts should only intervene where there are clear violations of due process. Applying these principles to the present case, the High Court is not required to assess whether the Senate made the right decision, but should only determine whether the procedure followed was fair and constitutional. A proper reading of this decision in light of the Constitution requires that this court can only engage in a merit review of the decision of the Senate if the decision of the Senate on the applicable law and/or evidence was so profoundly incorrect that no reasonable quasi-judicial body properly applying its mind to the law and the facts would have arrived at that conclusion, notwithstanding the procedural compliance of the process. This court is satisfied that the charges laid before the Senate and which were considered by the chamber in favor of impeachment were of a nature that meets the requirements of Article 181, Clause 1 of the Constitution, and the petitioner has not shown that the Senate's analysis of the applicable law and evidence was so profoundly incorrect that no reasonable quasi-judicial body properly applying its mind to the law and the facts would have arrived at that conclusion, and thus warranting interference by this court. With regard to the procedural and due process probity of the Senate's processes, this court notes that the unique circumstances of this case and the manner in which the parties canvassed the question of fair hearing require that the same be analyzed separately and not as part of an omnibus procedural and due process examination. In that regard, while the court finds that the procedural and due process boxes were ticked in the Senate, the question of whether there was a substantive fair hearing in the Senate shall be dealt with separately and below. The right to a fair hearing is a fundamental constitutional guarantee enshrined under Article 50 of the Constitution of Kenya 2010. The petitioner claims that her impeachment was invalid due to the alleged violation of her right to a fair hearing during the Senate proceedings, a position supported by the first, second, and seventh interested parties, but strenuously opposed by the respondent and the third, fourth, fifth, and sixth interested parties. The relative positions of each of the parties on this issue were extensively set out earlier in this judgment, and thus there is no need to repeat them here. From those extensive articulations of their relative positions, it is clear that the issue of fair hearing has 5 distinct sub-issues, being A, whether the petitioner was afforded sufficient opportunity to present her case; B, whether the senators were given adequate time and opportunity to consider the matter; C, what is the probative value of the statements both during and after the fact by a section of the senators; so it should be 6. D, whether there were disruptions or disorder of a nature as to deny the petitioner a fair hearing; E, whether in the Senate proceedings the petitioner was subjected to discriminatory or unfair treatment; and F, whether there is evidence that there was a preconceived outcome and thus the hearing before the Senate was a sham. The question of whether the petitioner was afforded a sufficient opportunity to present her case requires an examination of both the individual milestones in the hearing process as well as an overall view of the entire Senate process. In both aspects, the petitioner has provided evidence in the form of the Hansard that shows that the procedural milestones were met and they were of a sufficiently proper nature as to insulate them from an adverse finding by this court. The petitioner may disagree with the overall outcome of those steps and how they connected as a whole, but the petitioner has not shown a deficiency in each or in all as a collective that would require this court's interference. Another aspect of the petitioner's argument is that she was only given 2 minutes to make a personal statement at the conclusion of the proceedings and that she did not get the chance to deliver it. However, the court's review of the Hansard and video recordings indicates that the Speaker of the Senate granted her the opportunity to speak. The uncertainty regarding whether she remained silent by choice or whether there was a technical issue with her microphone does not alter the fact that she was given the opportunity to address the Senate. Moreover, her legal counsel did not raise any objections during the proceedings, either regarding the time allocation or any technical difficulties. Courts have previously held that a party who fails to object to a procedural issue at the appropriate stage cannot later claim to have been denied a fair hearing. In Republic versus Public Procurement Administrative Review Board and another ex parte Gib Africa Limited and another 2012, the court ruled that a party who fails to raise an objection at the appropriate stage of proceedings cannot later claim to have been denied a fair hearing. Since the petitioner did not object at the time, and there is no evidence that she was prevented from speaking, the claim that her right to a personal statement was violated lacks merit. Similarly, the petitioner has failed to show that the senators did not have sufficient time and opportunity to consider the matter. The respondents and the interested parties who oppose the amended petition are correct in stating that it is not for this court to impose its own view on how much time should have been allocated or how the matters should have been laid before the senators, but rather to see if they met the basic requirements of a fair hearing. I note that the impugned resolution process commenced substantively with the Senate's decision not to have a special committee hear the matter and prepare a report which would be voted on by the House, excuse me, but rather have the entire Senate sit as a committee of the whole House and vote as the special constitutional procedures applicable require. This, to my mind, meant that each senator who participated had sufficient time and opportunity to consider the matter. One of the petitioner's key complaints is the senators were only allocated 3 minutes each to debate the impeachment motion, which she argues was an insufficient amount of time. The petitioner has presented signing-in forms suggesting that some of the senators may have objected to the short debate time, as well as statements made thereafter about an alleged admission of insufficient time and opportunity by some of the senators. However, for such an argument to hold legal weight, the petitioner should have ensured that the senators who felt constrained by the debate time had sworn affidavits confirming that they were unable to effectively express their views and consider the matter and file them in these proceedings. Courts have consistently held that procedural fairness should be analyzed holistically rather than focusing on isolated aspects of a process. In JSC versus Mbalu Mutava and another 2015, the Court of Appeal emphasized this point. Applying this principle, this court finds that the limited debate time did not compromise the fairness of the proceedings, as the impeachment process did not involve a committee report requiring lengthy deliberations. Additionally, senators had access to the impeachment report beforehand and were given an opportunity to ask questions and deliberate before the proceedings. Therefore, the claim that the short debate time rendered the hearing unfair is not substantiated. The petitioner also argues that the impeachment proceedings were chaotic and disruptive, thereby affecting the fairness of the process. However, an examination of the petitioner's own video evidence, as well as the official Hansard, does not support the claim that the chaos was of such a nature that it negatively impacted the fairness of the hearing. Courts have previously ruled that not every procedural irregularity renders a process unfair. Only those that materially affect the fairness of the proceedings are considered grounds for judicial intervention. In Dry Associates Limited versus Capital Markets Authority and another 2012, the court held that not every procedural irregularity is fatal. Only those that cause substantial prejudice to a party's rights will justify the setting aside of a decision. In this case, the court has determined that while the proceedings may have been politically charged, there was no significant disruption that prevented the petitioner from presenting her case effectively. Therefore, the argument that procedural chaos rendered the hearing unfair is not supported by sufficient evidence. On the penultimate sub-issue, the question of gender discrimination and denial of equal treatment under the law, there can be no denying that, zooming out from the present case, we remain a nation that regrettably has not made the strides towards gender equality and promotion of the participation of women in governance that a nation of our democratic credentials should have made. There can be no denying the fact that despite all our other successes in constitutional implementation and deepening our democracy, the area of fostering inclusivity and diversity in political representation remains one in which we need to do much better as a country. It is difficult for women to successfully demonstrate gender bias and denial of equal protection of the law in the governance arena, because more often than not, these biases and discriminatory treatments are not brought out starkly by those who perpetrate them, but rather they are subtle yet significant actions, decisions, and omissions that create an unequal playing field for women. That being said, the petitioner and the second interested party have not particularized this complaint with specific reference to the Senate's proceedings, or shown an aspect or element of the proceedings before the Senate that show gender bias against the petitioner. Perhaps this is because, while we have a wider problem with gender bias, the Senate conducted its proceedings strictly without any form of gender bias against the petitioner. Had the contrary been demonstrated to the required standard, then on this sub-issue of 7 main issues, this court would have had no hesitation in quashing the Senate's resolution. The final claims raised by the petitioner relate to the dating of the Gazette notice and the clerk of the Senate's letter, as well as the speed with which the Senate conducted the impeachment vote. The Senate contends that the Gazette notice and the clerk's letter were both dated 20th August 2024, despite the vote taking place on 21st August 2024, which she argues is a proof of a predetermined decision. Under Section 107 of the Evidence Act, the burden of proof is on the petitioner to establish that these documents indicate a premeditated decision rather than being the result of a typographical or clerical error or even a good faith mistake. The petitioner failed to provide evidence to refute the simpler explanation that the date discrepancy was a minor administrative oversight rather than the much more serious claim of a proof of a rigged or predetermined process. Similarly, the claim that the Senate rushed to conclude the impeachment or sat on non-gazetted days has not met the required threshold, as there is no requirement that the impeachment proceedings must last a specific duration. Courts have previously held that the expedited process is not inherently unconstitutional unless it is demonstrated that it deprived a party of an opportunity to be heard. In Republic versus Speaker of Nairobi City County Assembly and another ex parte Evans Kidero, 2017, the court held that an expedited process is not inherently unconstitutional unless it is shown that it deprived a party of an opportunity to be heard. The petitioner has not demonstrated how the Senate's action of expediting the hearing and determination of the matter before it deprived her of an opportunity to be heard or was indicative of a preconceived outcome. An analysis of all the applicable evidence demonstrates that the petitioner was accorded all the procedural safeguards necessary for a fair hearing, including the opportunity to present evidence, respond to both allegations as well as questions from the senators, oppose the county assembly's position, and make a final statement. Excuse me. The Senate proceedings followed standard parliamentary procedure, incorporating an opening statement, presentation of evidence, an opportunity for senators to ask questions, and a closing statement. The court has assessed the totality of the impeachment process and found that the petitioner was given ample opportunity to present her case and respond to allegations leveled against her. While the petitioner has pointed out certain aspects of the proceedings that she considers unfair, such as limited debate time, the opportunity to make a personal statement, the alleged chaotic nature of the proceedings, the timing of official communications, and the perceived haste in concluding the impeachment, none of these claims have been substantiated sufficiently to warrant a finding that her fair hearing rights were violated. Therefore, the Senate's impeachment process was procedurally sound and does not warrant judicial intervention on grounds of unfair hearing. Conclusion. Paragraph 133. Gubernatorial impeachment is an invaluable safeguard against impunity and abuse of office that must be jealously protected. It must not be allowed to become an avenue for fighting political proxy wars or resurrecting the ballot box contestations that were determined by the electorate when it chose a particular candidate to hold the office of governor. In that regard, the Senate, as a national legislative body that is able to rise above the din of the county-level gladiatorial arena, is uniquely placed to safeguard the sanctity, probity, and vitality of this very important accountability measure. Watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. Interventions by the courts come further down the impeachment path, and thus it is the duty of the primary duty bearers, the concerned county assembly and thereafter the Senate, to ensure that impeachment remains as constitutionally envisaged. Turning back to the present case, and in light of the foregoing, the inescapable conclusion is that the amended petition dated 23rd December 2024 has not met the required legal threshold for success. As outlined above, certain aspects of what was laid before this court and submitted on extensively by the parties has been reserved for determination in another fora, a situation occasioned by the petitioner's choice to split her grievances into two petitions pending before two different high court stations. What this court could safely determine without falling into sub judice was insufficiently articulated for finding in favor of the petitioner. While ordinarily course would follow the event, in the circumstances of this matter, I am satisfied that it is fit, just, and proper that each party bears its own costs. Before I rest my quill by penning the disposition and final orders, I must thank the learned counsel for the parties in this matter for their industry, adherence to strict and short timelines, and the professional courtesy they extended each other. The breadth of their written submissions and the manner in which they ably highlighted those submissions orally made this court's task of judgment writing a lot easier. I would also like to thank the parties for maintaining decorum while attending court sessions, despite this being a highly emotive and charged matter. Disposition and final orders. Consequently, and for the following reasons, this court finds and determines that A. The amended petition dated 23rd December 2024, which is the subject of the proceedings herein, is found to be without merit and is dismissed accordingly. B. The Gazette Notice number 10351, volume CXXV1, number 130, dated 20th August, published on 21st August 2024, and issued by the respondent communicating the decision and/or resolution of the Senate to remove the petitioner from office as the governor of Meru County by way of impeachment is affirmed for the purposes of these proceedings. C. Consequent to A and B above, the subsequent constitutional and statutory actions are free to take place as per the applicable timelines. And D. Each party shall bear their own costs. Dated, signed, and delivered in open court on this 14th day of March 2025. I did, before Councillor Mutuma, before you speak, I did state at the beginning that I would give you hard copies. As I was reading through, I saw one or two spelling mistakes, little double words. I will work on those. It will be uploaded into CTS. You'll have it today. So I'll do that. You'll have it on CTS today. I have signed the hard copy as required by the law with my handwritten corrections of those spelling mistakes. Yes, Councillor Mutuma?
Yes, thank you, Your Lordship, for the judgment. We note the expeditious nature in which the court has been able to dispose of this matter.
Yes.
My instructions, Your Lordship, is that we note from your judgment that a majority of the issues raised in the petition remain unresolved.
Yes.
And have been shelved and reserved for determination by the petition pending in Meru.
Yes.
We are therefore of a strong position that there is need to grant the petition an opportunity to have those issues which are the majority heard and determined.
Yes.
And since the court has had the opportunity to hear the issues being canvassed by all parties extensively,
Yes.
it will then appreciate the need for the issues, for the very weighty issues to be determined.
Yes.
As such, Your Lordship, my instructions are to humbly request you to grant us temporary relief in whatever nature, but specifically an order of status quo to be maintained in the prevailing period, to allow the petitioner ably prosecute the issues pending before the Meru court.
Yes.
And secondly, to also consider exercising a right of appeal in the Court of Appeal.
Yes.
This order of status quo, Your Lordship, can be structured in such a manner that it will be time bound with the effect of automatically lapsing should the petitioner not have gotten a relief either from the Meru court or from the Court of Appeal. We submit, Your Lordship, that there will be absolutely no prejudice on any of the parties if orders of status quo are maintained. In any case, it is the situation that has been prevailing since August 2024. Having that situation maintained for the next few weeks or months will not in any way prejudice the petitioners.
This one, please repeat the period.
The period, my submission to Your Lordship is that in any case, the status quo has been prevailing since August 2024. There will be no prejudice if that same situation is maintained in the next few weeks, or rather for the next few weeks or months, just to ensure that the very weighty issues that the court has appreciated will have an opportunity to be determined on merit. The contrary is true, Your Lordship, that should an order of status quo not be issued, then effectively, whatever is pending in Meru, whatever is pending in the Court of Appeal, like the court has already noted, is all rendered an academic exercise. By dint of Article 23, we humbly request the court to issue conservatory orders court judgment. And to expedite our next move, Your Lordship, we humbly then request the court to direct the Deputy Registrar to supply us with type proceedings in this matter. And a copy of a certified judgment. That is all, Your Lordship.
Yes, thank you, my Lord. My Lord, we oppose the application for the first reason that this court has identified.
You oppose?
Yes, we oppose the application. My Lord, in your judgment, this court has identified that the petitioner's action of approaching two different courts was for this purpose exactly. This application is meant to dismiss the respondents from enjoying the fruits of their judgments after this court has started and had parties on merit. I know it is not true that there will be no prejudice. The court has found that on merit, the Senate did conduct a proper process within the law.
Yes.
And further suspending that process is not in the interest of justice. It is not in the interest of Article 10. And it is not what is envisaged under Article 181.
Yes.
My Lord, the petitioners having been found be worthy of leaving office pursuant to Article 181. She has remedies in other courts, but at this point, this court is found insufficient. My Lord, the Meru court is seized of the matters pending before it, and you have rightly declined to deal with those matters. That court can make appropriate orders concerning this issue. That court can quash any process. They have the power to do that based on the material before them, which is not before you this afternoon. My Lord, in the Wajir impeachment case, the court quashed the impeachment and the process proceeded after that. But for this court to be asked to take action based on the matters before the court in Meru is not proper, and it is negating the judgment delivered this morning, and further suspending a proper decision of the Senate. My Lord, we oppose. Thank you.
Just a moment. So we have quite a number of interested parties. So I will call on one from each side. First interested party, Councillor.
Thank you, Malone.
Yes.
Thank you for the industry that the court has shown in determining this dispute within the timelines has slowed down. A lot we wish to submit to associate ourselves with the application by the petition. With regards to the request for a status quo order, this will enable the parties to ventilate the issues that the court has so referred to the petition that filed in Meru.
Yes.
And these interim orders will be able to avoid the disruption of the governance. We also wish to request for time copy of the proceedings as well as certified copies of the judgment. That is all I'm saying.
Council Kirimi.
Thank you, my lord. On behalf of the interested parties who opposed the petition, my lord, first and foremost to thank you for the good judgment that you delivered. And my lord, on behalf of all my colleagues who appeared before you, and as the senior most counsel perhaps who appeared before you, we are sincerely grateful for the opportunity to canvass the issues we did before you. My lord, so that I won't come again before you,
Yes.
we are also sincerely grateful to yourself for the professional courtesy that you extended to us.
Yes.
My lord, in a specific way, we are very grateful that you found in your heart to forgive us when we did not appear to be proper before you.
Yes.
And we thank you specifically for pushing yourself and ourselves to meet the strict timelines that you set to canvass this petition before you. My lord, turning to the application by Mr. Mutuma, we do oppose the same.
Yes.
First, you are now ranked as official. Secondly, my lord, the weighty issues Mr. Mutuma is raising from the bar cannot be raised in an oral application. We kindly suggest that the petitioner finds it proper to file a formal application before you for urgent consideration and for a formal opportunity to all parties opposed here to file a response. Thirdly, Your Lordship, by making any decision that will amount to a stay of the negative orders you just granted, with all due respect, Your Lordship, you will be sitting on an appeal of your own decision. My Lord, this court will be making its orders appear inferior to orders of other courts. We urge Your Lordship not to be persuaded at all to grant any orders of status quo. My Lord, fourthly,
Yes.
there is grave injustice and prejudice that is going to be suffered by the people of Meru and the voters of whom I represent by an order of status quo or stay or an umpteenth time applied for conservatory order. My Lord, that will be in breach of Article 10 and Article 1 of our Constitution. My Lord, fifthly, we are alive that the petitioner has a right to appeal against the decision. The superior courts may grant orders of stay if they properly seized of that legal mandate. But your Lord, as far as you're concerned, you've done your work. We kindly ask you not to allow a stay of that decision even for a second. People of Meru have been waiting for this judgment. The court has rendered itself. It's upon all of us as parties to take up our other rights, and the constitutional frameworks and set standards should now take effect. We are established.
Thank you. So give me about 5 minutes to write. Yes.
The amount is not public inside. I beg for 5 minutes to watch.
Now, because we have so many interested parties, if I extend to yourselves, for fairness, I'd have to extend to others. It's a straightforward issue. I think every council who walks into a court in this country and beyond has an application for stay in their mind, or how they will attack an application of stay if their side has won. So I'd request that you allow me to give my ruling, and we leave it at that.